All right, everyone, we're back. We're taking a look at some privacy cases and issues. In this video, we're going to take a look at a few key cases and a few that are not as well known. And we're going to deal with technology and, again, always we're not too far away from both the issues of personal privacy and property as well. So Fourth Amendment issues of search and seizure. Here we go. So I asked you to read this about this case, Zerker versus Stanford Daily. Stanford Daily, of course, is the periodical you see in the upper right there. And what was happening in this case was raised an interesting question. So investigators were looking to they're gathering evidence on a third party, and it looked like there was some information that might have been in possession of this newspaper that could have been used to identify these other people. So again, we're dealing with this finicky border between public good and personal privacy. But in this particular case, as some of you are already aware of, when you're dealing with the press, that's another First Amendment issue. So what happened in this case was a subpoena was issued, and there are different kinds of subpoenas. The subpoena duces tecum is a particular kind of subpoena that is a writ to hand papers over to a court. It's not subpoenas can be for different things, and this was issued in this particular case. So it was a court requirement. So it's kind of, it's not the same as a police officer knocking on the door and looking for evidence, right? But it's gathering evidence. So what eventually came of this case, and you read a little bit about this, is a warrant based on probable cause to search for evidence of, and this is dealing specifically with third party. Is that a violation of the Fourth Amendment and possibly of the First? Right, the Congress shall make no law regarding the the press and others. So in this case, they said no. Because of the ins and outs of that particular case, they said the critical issue is not the suspicion of the owner. So the person who was in possession of this information that could have identified the third party, they were not suspects. They were not suspected of any wrongdoing or being involved. But there was a reasonable cause that some evidence was in their possession. So it's interesting that it has ramifications for people who might be in possession of evidence for a third party. And in this particular case, the fact that they were the press doesn't necessarily grant them special protection from that. Although we've seen that the Supreme Court is really sensitive to First Amendment issues regarding the press too, and we'll see regarding religion when we look at our religion unit too. So we get to a really famous case. This is Olmstead versus U.S. in 1928. So we're talking about new technologies, and a brand new technology, fairly new technology, was the phone, right? Literally a landline that could connect people's voices and what's transmitted. This is an era of bootlegging when producing alcohol was against the law. So it comes at an interesting historical moment as well, not just in terms of the technology, and it had to do with communicating across state borders through the telephone. So it really kind of had to be decided, is this, can you gather information tapping a phone when it pertains to gathering evidence for a crime, or can you not? Is that something that's protected? So it gives us a glimpse into that kind of decision-making, what basically needed to be decided at that moment. So is evidence acquired through a phone tapping the violation of the Fourth Amendment? In 1928, the court said no, that's not a violation. Law enforcement can gather evidence without a warrant to tap a phone. Why? Because as they argue in 1928, there's no search, right? They didn't search anything. There's no seizure, and there's no entry. So it's something else. The Constitution doesn't decide on that. It doesn't imply that. So it's pretty much legal. The Fourth Amendment, they go on to say, can't be extended to include electric signals along wires. It's unfathomable that that's what the Constitution actually says. Here is a really one of those, I don't want to say rare, but one of those clear cases of one case overturning another completely. Because then we get to cats. A generation or so later, in the 1960s, kind of different era, different technologies, slightly different different attitudes about privacy and the use of, how the government interacts with private individuals, what crime is and what's necessary. And so in 1967, it was a phone tapping case to gather evidence. It's bugging or phone tapping telephone conversations as evidence. Is that constitutional? And in this case, in the Warren court said no. The Fourth Amendment, they said, protects people, not just tangible things or areas. And this is always, it's always important when you see a case overturned. Dissenting voices are always important, right? We tend to just look at the majority opinion and that's it, move on. But the dissenting opinions can always come back and be used as grounds to overturn a case, depending on the makeup of the court and the issues that are being dealt with in the future. So what's interesting about this is that they argue that the Fourth Amendment protects people, not just places, right? So you as an individual have a right not to be bugged. What one intends to keep private on a private phone conversation may be protected, they said, even if it's in a public sphere, even with a payphone. And in this particular case, they said, okay, just to cover your bases, you could have gotten a warrant instead of just picking up the phone or just tapping the lines when someone picked up the phone. The framers really couldn't have predicted any of this technology, of course. So think of Wi-Fi and hotspots and cell phone technology, which raises an interesting question. Here's a pop quiz. And this is based on some cases. Can the police access your social media data without a warrant? Could a police officer right now get on your Facebook account, Instagram, Twitter, whatever, and gather information that might be used as evidence against you? Can they do that? So think about that for a moment. Some of you probably already know the answer or feel strong about that it's actually yes, they can do that. The basis is that, again, going back to some of the earlier cases, Mapp and Greenwood, that they should not be prevented from looking at things that other private individuals might as well. Or I guess that Serralo applies as well. So if a private civilian could go on Facebook and check your information, why couldn't they do that? Why are they prevented from that? So of course they can. It's interesting, and it raises questions about entrapment too. This is not entrapment. This is surveilling and gathering evidence, right? But that's without a warrant. So interesting. So hopefully you're getting a sense of the boundary there, what the boundary between private and public is, what's protected by the Fourth Amendment and others. Hopefully that's becoming clear to you, at least the historical context of this. Now we're going to look at some older cases that give us some guidance about property. So the Parham versus Decatur County in 1851 gives us a little glimpse into how another component of the Constitution, of the Bill of Rights, has been applied, and why this has to do with property. So this concept known as eminent domain. The word eminent is not imminent. There are several words that sound like that. It's eminent, which means sort of the power of the government. It's a phrase, eminent domain, that suggests that the government, under some circumstances, may seize private property, or even public property for that matter. So it's a formal condemnation of property with a fair price paid had to happen in this particular case. Just establishing something that had already basically been established through common law, that the government may not willy-nilly take your property. There have to be at least two key components that have to happen. There has to be a fair price paid for that, and there has to be a public use. So the critical issue in this particular case proved to be the second of the two major principles, and that is that there has to be a public necessity. There has to be basically a good cause that will benefit the public, and there has to be a fair market price paid for that property. They can't pay you $1 unless that's the fair market. They can't pay you too much because that might be seen as favoritism or something. It has to be fair, something fair and market-based. Right? So those are the two basic reasons, conditions under which the government may take your property. And of course, this goes back to the Magna Carta in 1215. So why in the world did I ask you to read a part of the Colorado Constitution from 1876? Well, it's for this reason. Because this is really one of the early situations in which a state was struggling with how to apply Amendment 5, this eminent domain principle, to westward expansion. And so what was happening was, as you might know, the transcontinental railway was being built, and property was just taken by the government and then sold or given over to the big corporations to build the railways. So is the building of a railway, even though it benefits those corporations, isn't that still public good? Is that something that the government has a right to do, to seize someone's property and then someone else can actually benefit from that monetarily? And that's really interesting that that's sort of in the Constitution there as it was being established. So again, once again, there has to be a public purpose and there has to be just compensation. It doesn't prevent third-party corporations from benefiting from that. So we get to a pretty controversial case. Obviously, if it gets to the Supreme Court, it's going to be controversial. This one maybe is partially because it's so contemporary, partially because it might cut so close to home for many people. And if you see that image there, this is a home in the neighborhood of New London, Connecticut. This is a case called Kelo versus New London, Connecticut, which happened not that long ago. The Rehnquist court presided over this one. And what happened was there's a neighborhood that some developers felt and some city planners felt was I'm trying to think of the terminology they used. It was undesirable. It didn't look good. It wasn't nice. It wasn't like a nice neighborhood. And so they decided they had this long-term plan to consider this condemned, this whole neighborhood, and then they could destroy it and sell it to developers and make nice upscale homes and attract more people. So there's your public purpose there. And so what happened is, in this particular case, the Supreme Court said that the government of Connecticut was able to do this. They were given broad latitude. And what's interesting, like with the railway cases, they lent the power of eminent domain to the private sphere, and that's constitutional according to the Rehnquist court. So this is sometimes called blighted property. It has to be declared blighted. A blight is something that is not desirable. It's if you think of a blight in terms of crops, it's something that is disastrous. It can cause a lot of infestation. The term is very loaded. And these were not slums or crack houses, I want to point out. It was perceived as something that could have been developed and to bring more money back into this neighborhood. So this is what's known as gentrification. This happens all across the country, and it's controversial, where neighborhoods are considered undesirable, and they are developers buy the prices low, buy the property low, and then they develop it and sell it for money, and they make money that way. And everyone wins, right? Because then nicer stores, you get IKEAs in there, and you get Targets and things like that. That's all kind of informal through the economy. What's interesting about this and this trend is when the government's involved in it, when they use this constitutional principle of eminent domain, and they lend it to corporations. So that's a pretty controversial thing, and that could happen in your neighborhood, right? That's theoretically possible, that your home could be destroyed because it's in the public good to have a Target built in your home, or McDonald's or something. Now, that's not likely to happen, and of course there's sometimes pushback on that, but according to Kelo versus New London, that theoretically could happen. So anyway, this is quite interesting, and we're going to see one more video with some of these slides, and we're going to round out the issue of privacy with a few other cases. All right, thank you very much.